£285,000. That's the amount Shropshire Council added back to Gillian Preece's financial assessment in July 2026. The full market value of the three-bedroom semi-detached house in Shrewsbury she'd transferred to her daughter 7 years and 4 months earlier. Gillian was 74. She'd had a stroke. She needed residential care at £1,300 per week. And she'd been told, by a friend, by a forum post, by someone at a dinner party years ago, that if she waited 7 years after giving away the house, it would be safe from care home fees. She waited. She counted. She believed the rule was real. It isn't. The 7-year rule applies to inheritance tax. It comes from a completely different part of the law. Under the inheritance tax framework, gifts you make more than 7 years before death fall outside your taxable estate. That rule is real. It's written in the Inheritance Tax Act, 1984. But it has absolutely nothing to do with care home fees, council means testing, or local authority financial assessments. 0. There is no time limit, no 7 years, no 10 years, no statutory cut-off of any kind on how far back a council can investigate when it suspects you deliberately reduced your assets to avoid paying for care. If you own property and you're over 60, the next 22 minutes will explain what actually happens to your house when you or a family member enters a care home. Not what the internet says, not what your neighbor thinks, what the Care Act 2014 actually requires. And I'll show you the 5 beliefs passed around kitchen tables, shared in Facebook groups, repeated by well-meaning solicitors, that are costing British families tens of thousands of pounds in penalties and lost assets. There is one legitimate route to fully funded care that sits outside the means test entirely: NHS Continuing Healthcare, and most families never hear about it until the house is already under threat. I'll get to that in the second half. The legal framework starts with Annex E of the Care and Support Statutory Guidance, issued under the Care Act 2014. When a local authority suspects someone has reduced their assets to avoid contributing to care costs, it applies a 2-part test. First, was avoiding the care charge a significant motivation for the transfer? Not the sole motivation. Not even the primary one. Significant. That word does more work than any other word in English social care law. Second, did the person have a reasonable expectation of needing care at the time of the transfer? Gillian transferred her house at age 67. She was fit. She was healthy. She had no diagnosed conditions. Her solicitor is now arguing that at 67, care need was not reasonably foreseeable. Shropshire Council disagrees. And this is where the system gets genuinely uncertain, because different councils draw the line differently. Some accept that transfers made before age 70 with no health concerns carry weak evidence of deprivation. Others have successfully challenged transfers made by people in their early 60s. The case law is inconsistent on this point, and the local government and social care ombudsman has criticised councils for both overreaching and under-investigating in equal measure. The landmark case is Yule versus South Lanarkshire Council, decided in 1998 by the Scottish Court of Session. It confirmed that councils can look back as far as they consider necessary. No statutory limit, no 7 years, no 6 months. The judgment has been cited in every English local authority deprivation policy published since. It remains the controlling authority in 2026. Roger Phelps, 69, from Exeter, put his bungalow into a discretionary trust in 2014, 12 years before any care need. He was running a market stall 3 days a week, active, independent. In 2026, Roger developed vascular dementia. Devon County Council examined the trust during his financial assessment. Because the trust was established after Roger had turned 57, the council's social worker argued that care need was foreseeable. The trust provided no protection. The bungalow's value, £210,000, was added to Roger's assessment as notional capital, full self-funder. Notional capital. That term is the engine of this entire system. Under Annex B of the Care and Support Statutory Guidance, if a council determines that you deliberately reduced your assets to avoid care charges, it calculates your contribution as if you still owned everything you gave away. You don't have the money, you don't have the house, but the council charges you as though you do. And if you can't pay, because the asset is now in someone else's name, the council has the power under Section 70 of the Care Act 2014 to pursue the person who received the asset directly for the debt. The recipient's liability is capped at the value of the benefit they received. So if Gillian's daughter received a house worth £285,000, the council can pursue her for up to £285,000 in unpaid care fees. I'd be curious to know, has your family ever discussed transferring a property to avoid care home fees? Because every week I hear from viewers who were told by a friend or an advisor that putting the house in the children's names would solve the problem. If that conversation has happened in your family, tell me in the comments. The number of families walking into this particular trap appears to be growing, not shrinking. The second myth. If you sell your house and spend the money, the council can't touch it. This sounds logical on the surface. You can't be assessed on money you no longer possess. But it collapses the moment notional capital enters the picture. Patricia Hollowell, 71 from Barnsley, sold her late mother's house in 2023 for £162,000. Over the following 18 months, she gave £40,000 to each of her two sons, spent £22,000 on a new kitchen, £15,000 on a holiday, and kept £45,000 in savings. When she entered care in early 2026, Barnsley Council assessed her liquid capital at £45,000, above the upper threshold of £23,250. But they also investigated the £80,000 in gifts. The kitchen and the holiday were accepted as reasonable expenditure. People are allowed to spend their own money. The £80,000 given to her sons, made after Patricia had already been diagnosed with early-stage Parkinson's disease, was not accepted. The council added £80,000 in notional capital. Patricia's total assessable capital, £125,000. Full self-funder. The upper capital limit in England is £23,250. The lower limit is £14,250. Both figures have been frozen since April 2010, 16 years without adjustment. Inflation has eroded their real value by more than 40%. The government announced plans to raise the upper limit to £100,000 and introduce an £86,000 lifetime cap on care costs. Those plans were scrapped in July 2024. The thresholds remain at 2010 levels and are confirmed unchanged in the Department of Health and Social Care charging circular for 2026/27. Between the two limits, tariff income applies, £1 per week for every £250 of capital above £14,250. A pensioner with £20,000 in savings would have an assumed weekly income of £23 from capital added to their actual pension income to calculate the assessed contribution. The third myth. Putting your house into a trust protects it from the means test. Companies advertising asset protection trusts or care fee planning trusts have operated in this market for decades. Some charge £3,000 to £5,000 for a discretionary trust structure. The marketing language is careful. Phrases like may help protect and can provide peace of mind. What they rarely state plainly is that councils can and do look through trust structures established after care need was foreseeable. The mechanism is the same Annex E test. If avoiding care charges was a significant motivation, and the marketing materials the family received when purchasing the trust often make that motivation obvious, the council treats the assets inside the trust as notional capital. The trust wrapper provides no additional protection against the means test. Some elder law solicitors argue that trusts established genuinely for inheritance tax planning, years before any health diagnosis, with clear non-care motivations documented at the time, stand on firmer ground. Others point out that councils rarely distinguish between the stated motivation at the time of creation and the practical effect at the time of assessment. The LGSCO has upheld deprivation findings where the trust was transparently designed to shield assets from care contributions, regardless of how the trust deed was worded. If any of what I've described has made you reconsider advice your family has received, or advice you've given to someone else, hitting the like button takes 2 seconds. It tells the algorithm to push this in front of families who are making these decisions right now, this month, without knowing what the CARE Act actually says. That genuinely matters more than you might think. Now, the fourth myth, and this one works in the opposite direction. Most families assume the house is automatically counted in the means test the moment someone enters care. They panic. They transfer. They trigger the deprivation investigation. The truth is more specific than the panic suggests. Your main home is disregarded, fully excluded from the financial assessment in 5 circumstances. If your spouse, civil partner, or cohabiting partner still lives in the property. If a relative aged 60 or over lives there. If an incapacitated relative of any age lives there. If a dependent child under 18 lives there. And for the first 12 weeks after permanent admission to a care home, the property is automatically disregarded under the 12-week property disregard, giving families breathing space to make decisions. Harold Nightingale, 78, from Bolton, entered a nursing home in March 2026. His savings were £11,400, below the lower threshold. His only significant asset was his house, valued at £195,000. Bolton Council offered him a deferred payment agreement. Under sections 34 to 36 of the CARE Act 2014, local authorities are legally required to offer a DPA, where the only asset above the threshold is the person's home, and the applicant meets the eligibility conditions. The council pays the care fees. A legal charge is placed against the property. Interest accrues at the gilt rate plus 0.15%. The loan is repaid when the property sells, when the person dies and the estate settles, or if circumstances change. Harold's family doesn't need to sell the house while he's alive. They don't need to rent it. They don't need to make monthly payments. Compare this to Gillian's outcome. Harold did nothing to his property. No transfer, no trust, no spending down. He entered the system as he was, qualified for a DPA, and his family retained the home. Gillian transferred her house, waited 7 years based on a myth, and now faces notional capital of £285,000 with her daughter exposed under Section 70. The family that tried hardest to protect the property ended up in the worst position. I know this is a lot of rules stacked on rules. The interaction between care funding law, property law, inheritance tax, and the Mental Capacity Act creates something that even specialist solicitors disagree about. But here's what matters to you right now in August 2026. There is one route through this system that bypasses the financial assessment entirely. Every capital threshold, every deprivation question, every argument about trusts and transfers. And most families never ask about it because nobody tells them it exists. NHS Continuing Healthcare, CHC. If your loved one's care needs are primarily health-related rather than social care needs, the NHS is legally required to fund their care in full. No means test, no capital assessment, no property valuation, no deprivation investigation, no upper or lower capital limit. The NHS pays everything. The eligibility test is clinical, based on the nature, intensity, complexity, and unpredictability of care needs across 12 assessment domains set out in the National Framework for NHS Continuing Healthcare and NHS-funded nursing care. This next section, A lot of families tune out because it sounds bureaucratic. Don't. This 2-minute explanation could be the difference between your family paying £67,600 a year in residential care fees and paying nothing. CHC eligibility runs through a 3-stage process. Stage 1, a checklist, completed by a trained healthcare professional, usually a nurse or social worker. If you score positively in at least 2 domains, you move to Stage 2, the Decision Support Tool, a detailed multidisciplinary assessment across all 12 domains. If the DST recommends eligibility, Stage 3 is a panel decision by the local Integrated Care Board. The national eligibility rate at full assessment has dropped to approximately 16.65% in early 2026, down from 31% in 2017, according to the King's Fund. But for fast-track CHC, used when someone is rapidly deteriorating or approaching end of life, the conversion rate remains above 90%. The conditions most commonly associated with CHC awards include advanced dementia with behavioral symptoms, Parkinson's disease with complex care requirements, motor neurone disease, end-stage organ failure, severe stroke with ongoing clinical rehabilitation, and cancer requiring continuous nursing intervention. If your family member has any of these and is being assessed for council-funded social care, or worse, is already paying as a self-funder, the first question should never be about the means test. The first question should be whether a CHC checklist has been completed. If you've stayed with me through all of this, through the myths, the thresholds, the legal references, the case studies, you're now better informed about care funding in England than most families who are already in the system. I'm releasing a follow-up video next week covering the exact process for requesting a CHC checklist, the specific words to use with the nursing home or hospital, the form numbers, and what to do when the Integrated Care Board refuses the assessment. Subscribing means you'll see it the day it drops, and given that the average nursing home placement in England now costs £1,267 per week, every week of delay is money your family may never recover. Here's what nobody connects, and this is the thread that ties all 5 myths together. The reason these myths survive isn't because families are careless or foolish. It's because the system has a structural incentive to let them circulate. Every family that transfers property, based on the 7-year myth, removes the possibility of a legitimate DPA. Every family that spends down savings in panic reduces the council's ability to recover costs through proper assessment. Every family that purchases an asset protection trust creates a paper trail that makes the deprivation finding easier to prove, not harder. The myths don't protect families from the system. They protect the system from families who might otherwise ask the right questions at the right time. Your action plan for this week. Monday. Check whether anyone in your family has transferred property or made large gifts in the last 10 years. If they have, write down the date, the reason, and the health status of the person at the time of the gift. That contemporaneous record is your first defense against a deprivation finding, and it costs nothing to create. Tuesday, log into gov.uk and search Deferred Payment Agreement. Read the eligibility criteria. If your loved one owns a property and is approaching residential care, ask the council specifically whether a DPA has been offered. If it hasn't, ask why. They are legally required to offer one where the criteria are met. Wednesday, request a CHC checklist from the nursing home or hospital where your family member is receiving care. Use the exact words, "I am requesting a checklist assessment under the National Framework for NHS Continuing Healthcare." That phrasing triggers a legal obligation to carry out the screening. They cannot refuse. Thursday, check the upper capital limit for your nation. England, £23,250. Wales, £50,000. Scotland, £35,000. Northern Ireland, £23,250. If your family member's assessable capital is near the threshold, do not make any transfers or large gifts before speaking to a step-qualified solicitor. Friday. If a council has already made a deprivation finding against your family, request the decision in writing with all evidence relied upon. Under the LGSCO's 2022 guidance, the council must document each step, the relevant transfer, the motivation inquiry, the person's explanation, and the balance of probabilities finding. If any step is missing, the finding is challengeable through the complaints procedure and ultimately the Ombudsman. The financial gap between these two paths is staggering. A self-funded residential placement at £1,300 per week for 3 years, the average length of a care home stay, costs £202,800. A CHC-funded placement for the same period costs the family nothing. A deferred payment agreement defers the cost, accruing interest, but preserves the property during the person's lifetime. A deprivation finding, triggered by acting on a myth, can result in the full assessed capital being charged immediately, with the recipient of the transferred asset pursued under Section 70 for a debt they didn't know they'd assumed. Gillian Preece is still in the care home in Telford. Her daughter has instructed a solicitor to challenge the deprivation finding on the basis that Gillian was 67 at the time of the transfer, had no diagnosed conditions, and made the transfer primarily for inheritance tax planning, not care fee avoidance. The solicitor believes the challenge has reasonable prospects, but the complaints process takes months. An ombudsman referral can take a year. Meanwhile, Gillian is being charged £1,300 per week. 52 weeks of that is £67,600. The house she transferred to protect her family is now the exact asset the council is pursuing to recover those fees from her daughter. The next video covers how to request and win a CHC assessment, because starting April 2027, pension pots also become part of your taxable estate for inheritance tax purposes, and the interaction between care fees, inheritance tax, and pension death benefits is about to get significantly more complicated. If you thought today's myths were dangerous, wait until you see what happens when 40% inheritance tax meets a pension fund that families assumed was protected. That video drops next week. Nobody loses their home to a care bill they understood. They lose it to a rule they were told didn't exist, and a myth they were told was law.